The question to Justice Jackson is as follows. Having served on both the Court of Appeals and our Supreme Court for some time, you have had the chance to author a number of opinions, both unpublished and published. Since we as both lawyers and voters often look to authored opinions to help us understand the judicial philosophy of a particular judge, please give us an example of an opinion you have authored which you believe should persuade us that your candidacy is one we should support, and explain why.
Thank you and good morning. I appreciate the opportunity to speak with you today. I am Justice Barbara Jackson, and I'm seeking re-election to the Supreme Court. It's been my privilege to serve you on that court for almost 8 years. You've asked me to cite an example of an opinion that I've authored that I believe should persuade you that my candidacy is one that you should support, and to explain why. I'd like to take a bit of license with your question and discuss a couple of cases because I believe it's important for all judges to deal with every case and with every party fairly and impartially, adhering to the rule of law. In Burley versus U.S. Foods, a workers' comp case, which was a 4-3 opinion that I authored in 2015, your association filed an amicus brief. The issue we addressed was whether a contract of employment had been made in North Carolina when it had been entered into in South Carolina and later modified in North Carolina. We concluded that the modification did not alter the state in which the contract had been made. The employee lived in Georgia. He had signed his contract of employment in South Carolina, and he was working as a delivery truck driver. At this point, his route did not include any stops in North Carolina. When his employer merged with another company, he was offered the opportunity to work to either leave employment or be supervised in North Carolina. Operations ceased in South Carolina. He opted to stay in the job and keep the same responsibilities. Once again, his route did not include any stops in North Carolina. After injuring his back, he initially filed for and was awarded benefits in Georgia. 2 years later, he filed for benefits in North Carolina. The full commission determined that they did not have jurisdiction over the claim. The Court of Appeals reversed in a divided opinion. The case was a matter of first impression for North Carolina. And generally, when we're considering a matter of first impression, I'm interested in learning how other states have handled the case. In this instance, several other states had considered this issue and generally had held that modification of a contract did not alter where the contract was made. Consistent with that decision, Larson's workers' compensation law stated that once the contract has achieved an identifiable situs, that situs is not changed merely because the contract is modified in another state, as when there is a change in salary or other benefits and made in the second state. We also took a look at the contract case law, but didn't find it as persuasive. Our analysis led to this conclusion. Ultimately, Section 97-36 authorizes compensation pursuant to North Carolina law if an individual's employment contract was made in North Carolina. The statute does not include the word modified. After interpreting this statute in light of its plain language and upon consideration of decisions from other jurisdictions, we conclude that Section 97-36 does not apply to a contract initially made in another state and subsequently modified in North Carolina. Ultimately, this was essentially a transfer in supervision, and it simply was not sufficient to create a contract modification. The second case I'd like to bring to your attention is Carnegie Farms versus Cross Creek Seed. And in that case, the defendant seller sought to limit damages available to plaintiff farmers who claimed that seed had been mislabeled, leading to a loss of crops and economic damage. Both the Defense Attorneys Association and the Advocates for Justice in that case filed amicus briefs. I authored the majority opinion in that case as well, in which the court concluded that it was the policy of the state, as expressed by the General Assembly and the North Carolina Seed Law, to protect farmers from the potentially devastating consequences of planting mislabeled seed. Defendants' limitation of remedies clauses were unenforceable against plaintiffs. I'm not going to belabor the case, but I just bring it up simply to make the point that as a judge, I'm not on the side of any party or organization. I'm on the side of the rule of law. During the past 14 years serving as a judge on both the Court of Appeals and the Supreme Court, I've sought to deliver fair and impartial justice, adhering to the rule of law throughout, writing clear opinions. I'm the only candidate in this race with judicial experience, and I've authored hundreds of opinions that demonstrate that I understand judicial restraint, the importance of ruling on the cold record that you attorneys bring to us on appeal. That is why I'm asking for your support and your vote this election season. Thank you for your invitation, and thank you for your time this morning.